I want to talk about a really good housing bill that's just been filed in the state of Montana by Senator Beard. So this is Senate Bill 146 in the state of Montana. And could be a real game changer in terms of making housing more available and affordable by increasing private property rights. So at present, obviously, local cities, municipalities have a lot of control over zoning in their own jurisdictions. They can impose often very arbitrary, very random, very expensive requirements and mandate only certain kinds of housing illegal to build, and all other kinds can be illegal, whether that's building a duplex, a triplex, accessory dwelling unit, a small apartment building, a townhouse. Anything that's not a standard single-family home on a big lot with a white picket fence is often illegal in too many places. And there are just tons of other laws that are too burdensome, that make it too difficult to build different kinds of housing. This bill, Senate Bill 146, could radically change that. And Montana has already done quite a lot to improve zoning. But this flips the question in terms of who should have the power over what you can build. And what it does, it inserts some very clever language. First of all, there's some legislative findings at the beginning that says the legislature has the highest interest in vindicating and protecting private property rights. That's IJ catnip. We love to hear all that kind of stuff. And then it talks about limitations on property use restrictions, and it says any property use restriction enacted by a governmental entity pursuant to Title 76 must be limited to those demonstrably necessary and narrowly tailored to fill a compelling governmental interest in public health or safety. So that means that if a local government, a city, a county wants to impose new laws that would downzone, that would encumber property right to make it harder to build, then they have to demonstrate that it's not just for some specious reason like neighborhood character or aesthetics. There has to be a reason that's firmly connected to health and safety, because we're in a housing crisis, right? And we shouldn't just be limiting housing because of specious, arbitrary arguments. And what this does, it borrows from the kind of language, what we call the tiers of scrutiny, when appellate courts are reviewing laws that are being challenged on constitutional grounds. There are different levels of scrutiny that can apply. There's strict scrutiny where the court will take a very hard look. Where there's a serious imposition on liberty, then the court will look closely to make sure that the bill is narrowly tailored to serve a compelling interest. And then at the opposite end of the spectrum, there's rational basis, which is any reason the government can pull out of its butt, basically. Doesn't have to even pass the sanity test. If they just say something, then the court has to accept it. So this bill, Senate Bill 146 in Montana, it takes that principle of strict scrutiny and applies it in the housing context. And it makes local governments, if they want to restrict private property rights, have to actually come up with some compelling reasons, which in almost all cases they're probably not going to be able to do. So although Montana's already a leader on this is really going to take them to the next level potentially. So IJ is excited about this bill. We'll probably support it, and I look forward to updating you on its progress as it goes through the legislative process.